Sir, please come forward and be sworn.
Thank you, sir. What do you do?
Manager of the Washington County Sheriff's Office.
And how long have you been in that position?
In that position since 2021.
Okay. And before that, what was your experience in law enforcement?
I started off at the Sheriff's Office in 2001. As a corrections officer, was a field training officer, was a sergeant in 04, ran transport and port security, lieutenant, went through the police and corrections academies, went to the MSA, special investigations, did some work at the agent's office.
Thank you. I'm going to have some questions about an incident in the jail, Washington County Jail, March 18th of 2024. Okay. Before I get to that, I suppose, do you know the defendant in this case, Christopher D?
Yes.
And how?
I'll stipulate the identification and that he's a law enforcement officer in the employee of Washington County Sheriff's Department.
All right, very good. So stipulate.
We'll move along. Thank you, Mr. Grucher. When did you become aware of the incident in question here?
There was an email notification that was made at the time D was a sergeant, and he was working midnights. And I remember waking up and checking my emails the next day, and I saw an email notifying that there was a use of force in jail. Reviewed it. Things stuck out to me.
Tell me about that.
What immediately stuck out was that the email indicated that Sergeant D sprayed a subject in the back seat of a police vehicle, an empty police vehicle, while she was in restraints.
Okay. That stuck out to you. What did you do?
Notified one of the lieutenants that we need to evaluate the situation when I came to work.
Okay. And so why did that stick out to you?
So ASR spray is used when somebody is a threat, and because she was in restraints in the back of a police vehicle, bars over the window, I had concerns as to whether or not that person was a threat at the time of the incident.
Could you tell what is ASR?
Aerosol Subject Restraint, commonly known as Mace.
Okay. And is that something that is issued to officers in the jail?
It is, sir.
Okay. And are there trainings regarding that?
Yes, sir.
That are required?
Yes, sir.
And are there policies regarding that?
Yes.
And are there, what is done, if anything, to make sure that the officers know about the policies?
Anytime there's a policy revision or anytime there's a policy that's newly published, it's sent out in a program called Power DMS. The employees are required to review the policies and electronically sign, and yearly Aerosol Subject Restraint. There's a training course that's pushed through Power DMS where the students have to participate in the training, watch a video, and then take a test.
Okay.
Successfully pass the test.
Specific to ASR?
Yes, sir.
Okay. Approach with people's proposed 4, 5, 6, and 7, which I've shown to Mr. Grucher. You mentioned that it's the incident that you were things stuck out to you because it was a use of ASR against someone who was handcuffed and in the back of a police car. Is that right?
Yes, sir.
And generally from the what is your understanding from the policies of the proper use of ASR within the jail?
ASR isn't classified anywhere in the force continuum. It can be used any time that the person that's applying force feels that lower forms of control will not be adequate.
Okay. Lower forms of control, what does that mean?
Muscling techniques, placing someone on the ground, escorting them.
Okay. Tell me about what you said, something about the individual not being a threat.
Yes.
Where does that fit in?
So ASR is used when there's a threat to staff or a threat to another person. And as the victim in the case was in restraints in the back of a police vehicle with bars on the window, it was difficult for me to see whether or not there was a threat to anybody else.
Okay. You talked about levels of compliance, using lower force to gain compliance. What does this mean, compliance?
To bring about a peaceful end to the situation, to bring about the lawful conclusion to an event.
Okay. When someone is, no, let's strike that. I'm not going to propose any hypotheticals there. Did you see, Commander, any justification for the use of ASR in that situation?
Objection relevance. Whether or not this officer sees that it's relevant is not the legal standard. Actually, under Graham v. Cards.
As to the form of the question, I'll sustain the objection. I'll allow you to rephrase the question, but I think it's phrased. I think it's.
Thank you. In a situation like this, Commander Shipakasi, where someone is handcuffed in the back of a vehicle, is that your understanding of the policies in your own training and experience, a situation where ASR would be necessary?
Based on my training and experience, what I saw, no.
Okay. And why is that?
Because the person was not a threat at the time that ASR was used.
Okay. Talked about compliance. What was being asked of the arrestee at that point to comply with?
Answering questions as to whether or not she was suicidal.
Okay. What the 3 core questions that was referred to? What are the 3 core questions?
If medical needs, you take medication, or any thoughts of hurting yourself.
Okay. And what is the purpose of asking those questions?
Just gauging whether or not they're going to be suitable to enter the jail to have the full medical evaluation done.
Okay. And if
also gauge whether or not we can place that person on any kind of observation.
And if someone does not answer those questions, what is done?
It's not unusual. We bring them into the facility, search them, possibly place them on precautions depending on the situation.
Okay.
Cross-examinations.
Commander, briefly, were you going to get the individual out of the car?
I'm sorry, sir.
Were you going to get this individual question out of the car?
No, sir, I wasn't there.
Okay, so you weren't there, but you determined that there was no threat to the officers that were, correct?
Based on the circumstances.
Okay, were her feet restrained?
No.
What direction were her feet facing while the sergeant was talking to her?
I'm not sure.
Okay, well, if the feet were facing the officer, could that be a threat?
No, because she was in the back of
Okay.
the vehicle.
Is that where she was going to be housed?
No.
Okay, so what do the officers have to do to house her?
Move her from the vehicle.
Okay, so if they open the door and the feet are facing the officer and they're unrestrained, is that a threat?
No, it's typically how we get people out of the vehicle.
So you're telling me that it's not a problem for officers to be kicked?
No, I said that's how we usually get people out of the vehicle.
Right, but that wasn't my question. Is that a threat to have the feet unrestrained at an officer?
Depends on the circumstance.
Okay. So did you see the demeanor of the individual that was coming into the jail?
I did.
She was kicking the back of the windows of the car?
When she was on the way there, yes.
She was screaming, yelling, insultive, combative?
Yes.
Okay. The officers have to make a determination to get her out of that car, right? How they're going to do it?
Yes, sir.
Now, the 3 questions were just a precursor to getting her out of the car, correct?
Yes.
The officers were actually there to extricate her from the car and put her in a cell.
Yes, sir.
Okay. Sergeant D and one other person, what was the other sergeant that was present? Do you recall?
We was Sergeant Merrick.
They're the ones that are in charge of getting this individual out of the car, correct?
Yes.
The other sergeant was a female officer, is that correct?
No, sir.
No? Were there female officers present?
Yes, sir.
And that was in part because not only do they work in the jail and handle all other prisoners, as a policy and procedure, you guys have female officers when available, deal with female.
When available.
Is that correct? And again, the ASR doesn't appear on the chart because you said that, and I want to get this quote right, not part of the continuum because it can be used anytime the officer feels or believes. And what was the rest?
Forms of control not be adequate.
Okay. No further questions.
All right, thank you. Any redirect?
One question, Commander Shipakasi, based on both the policies and your training and experience, is the preemptive use of ASR spray reasonable?
Given the circumstances, no.
Okay, thank you.
You may step down. Sir, please come forward to be sworn. All right, you may inquire.
Ed, what do you do, sir?
Currently, I'm a special investigator with the Washington County Sheriff's Office.
How long have you been doing that?
Since 2009.
Okay. And briefly, you have law enforcement experience before that?
Yes, I've been a certified law enforcement officer since 1974.
Okay, thank you. I asked some questions about an incident in the Washtenaw County Jail on March 18th of 2024, okay? How did you become involved in that?
I received a phone call from Commander Shipakasi stating that there was an incident that took place on March 18th in the Sallyport Correctional Facility at approximately 20 feet, 30 hours, involving WCSO personnel and an arrestee from the Atlanta Police Department.
Okay. And was that arrestee Rachel Damron his own?
Correct.
Okay. So you got this notification from the commander. What did you do?
I was instructed that they had some concerns, they being the administration, of whether or not the use of force was appropriate in this particular case.
Okay.
And I was instructed to conduct a non-administrative investigation.
Criminal investigation.
Correct.
Okay. And did you do that?
Yes, I did.
Okay. And you could walk us through a little bit about the steps that you took in this investigation.
Well, one of the things I did was I had a liaison with the corrections division, a lieutenant that I asked to assist in some of the technical aspects of the investigative process by gleaning information from audio and video information that existed in a series of cameras. Initially, information from the Sally Port, then it was information from the body cams worn by Sergeant D and Sergeant Merritt, as well as information from the cameras in the holding cell, as well as information of the activity that took place.
Okay.
That was the first step.
Your Honor, I'll stipulate to the admission of I believe we discussed body cam of Sergeant Day and the in-car camera from the point in time it reaches the Sally Port at Washtenaw County Jail to the end of this incident, correct?
Yes.
Yes, stipulate.
All right.
Thank you. That will be People's Exhibits 1 and 2. Mr. Miller, you obtained a number of videos.
That's correct.
And People's Exhibit number 1, which has been admitted by stipulation, is going to be the body cam of the defendant. And if you will give me a moment to connect.
You just cracked one. Hey, Rachel. Hey, my name's Sergeant D. I'm the supervisor that's on shift right now, along with Sergeant Merritt, okay? Hey, so I want to get you in, but I want to work with you. I don't want to. I do. I want to work with you.
So let's just be honest.
So I get paid whether you're here or not.
Whatever.
All right. So here's the thing. I want to get you in the door, and we are having a conversation right now. No, we're not going that way. Are you suicidal? Are you suicidal? I'm asking questions. Are you suicidal?
Yes, you know,
I have been treating you.
yes.
So,
Simple motherfucking question.
are you suicidal? Yes. Yes, I'm going to treat you with respect. Are you suicidal? Yes or no?
It's my question.
Do you have any emergency medical needs?
Yes or no?
I have been. Rachel, I'm trying to help you out.
Yes. Answer yes or no.
So here's what I'm going to tell you.
Yes, you're still not answering the question. Literally, all you have to do is answer.
I'm trying to get you taken care of, and I'm trying to work with you.
I'm asking you, are you going to treat me with respect?
Do you have any? I've already told you yes.
Yes.
This is the last time I'm telling
You're
you.
not going to treat me with respect.
Right now. Okay. Stand up. Stand up. I'll take a minute. Stand up. We'll take a minute. Same. She's going. Hey, go on. Go down on your knees. Lay down your stuff.
I'm happy to argue this down.
All right, very good.
Your Honor, the facts are pretty simple in the case and are not really in dispute based on the cross-examination that happened. Rachel Damron, his song was arrested for an offense, brought into the jail by YPD, and was a jerk. She was yelling and making a scene in the back seat of the car, as we saw in the video when she first got to the Sally Port. But it's the behavior of the defendant that's a question here. And we saw him approach the car, attempt to ask several questions, give no commands, not asking her to do anything, and not being any type of threat from this person. So setting aside for a moment that this is a police officer and all of the responsibilities, duties, and trusts that are placed in him, this is a person who is handcuffed and within a cage in the back of the vehicle who has a weapon used on her, that weapon being the ASR spray. But he was a police officer. I'm sorry, not a police officer. He was a corrections officer at the time who did have, who was there acting under the color of his office, performing or supposed to be performing duties of taking this woman into the jail. And his behavior by spraying her in the face when she was no threat, when she was not refusing any orders, when she was just not answering questions that Commander Shipakasi says happens all the time, that people do not answer those three core questions. She's not answering the questions and she insults him and he sprays her in the face with the ASR. That is a wrongful act. Going through the elements of misconduct, he is a public officer. He meets that definition. That's by stipulation. He was there. He was working, acting under the color of his office. And I ask that you do so.
All right. Just one question.
Yes, Your Honor.
Had this said the door had been open, either side, doesn't matter, and the arrestee is now out of the vehicle, and let's say is thrashing around, we wouldn't be here, I guess.
I'm not sure
and then the deployment of the ASR.
I'm not sure that's true. I mean, in your hypothetical, she is still handcuffed. She is still a restrained person and within the jail.
Assault with a dangerous weapon. First of all, there was no assault because his use of the tools that were given to him for compliance were lawful. That's what he's supposed to do. That is the purpose of the AR spray. No officers in that video were injured. The individual did not sustain any serious physical injury and was not subject to death. The individual was removed from the car and taken to a cell. If you look at the facts surrounding it, they're trying to create that there was some type of retaliation by Sergeant D. There was no retaliation. He was very patient with this individual. The decision not to issue a warning appears, based upon the video, to be more in line with extracting her from the car in a safe manner for both him and his officers, which was successful.
Okay, what
I'm saying is, as long as their actions aren't arbitrary. If you just decide that an individual sitting in the car is brought in, I'm going to spray him, that's an arbitrary use of force. But that's still not necessarily a felonious assault, and it still might not be misconduct in office. It may be a policy violation. Not every action is a criminal violation, Your Honor. And the officer, under the law, as long as his actions are not arbitrary, then yes, it's legal. That doesn't mean that it's not excessive. That's called a civil action. 1983 action. There's a whole list of things that officers aren't allowed to do that still aren't criminal, but they're charged in civil court all the time with violations. Officers are given special treatment. And as long as his actions weren't arbitrary, if there's a reason for it.
Yeah, Counsel, I get that they're given special treatment. I know the law in that area. I guess my question is, that's not sort of carte blanche.
It's not.
And so the question becomes, in this case,
Mhm.
where are you drawing the line? Because the only reason we're here is one side's drawing the line here and one side's drawing the line here.
But that'd be a factual issue, which I don't want.
I'm trying to figure out where your line is.
My line on the first one is, it's not a dangerous weapon.
Okay.
Okay. So therefore that charge shouldn't be bound over. On the second one, it's not corrupt intent. There was no perversion. There was no depravity. If you're using the policies to say that there was corrupt intent or depravity, the policies say it's up to the officer's discretion that they can use the ASR. They don't have to give a warning as long as, you know, there's
If the
certain things.
court would determine that a reasonable fact finder could conclude that it was an abuse of their discretion, does that then give rise to the potential that?
I would say no, because then you're basing the decision to bind him over on the policies and procedures and not the action. See, this is the dilemma that we talked about. Yeah.
You're not, that's not true. What you're saying is that the discretion of, it's really the discretion of the officer. That's what the policy is. I'm saying if one were to determine that it's an abuse of discretion, that equates to that depravity that we're talking about, or some corruption because it's an abuse of discretion.
No, that would mean
that be for the fact finder to determine.
I think you're mixing, in my opinion, Your Honor, I think you're mixing two different concepts together to get.
No, I think you are in trying to run me in a circle, because what I'm saying is if I take the policy.
Correct.
And I take that policy and I say, yes, they have discretion.
Correct.
But a reasonable fact finder could conclude that this is an abuse of discretion, which could be used as a factor to determine whether or not there's depravity or corrupt behavior.
Well, Your Honor,
then
I'll leave it.
Go ahead.
You to go and make your own determination. I'm not going to be able to change your mind necessarily on that. I think we're going kind of in circles, but I will direct you to the People v. Milton case, which is the assault and battery and the misconduct in office charge, which kind of started this whole thing in 2003. And in it, it kind of addresses your first part that you're kind of coming at me with this question. And it said that if our holding will strike fear in the hearts of police officers throughout the state, that no public officer under the color of his office will feel entitled to behave in the egregious manner that this defendant did, it would achieve that result. So it's saying to us that if our concern is that officers, when every time they use force, is going to be left to a jury to decide if that force was arbitrary and whether or not it's misconduct in office, the court says to the first part, if it's like this case, if it's horrible like this, what Milton did, then that's going to serve our purpose. But they go on at the end of that paragraph and says, listen, the defendants fear that in light of this result, any malfeasance on the part of officers will be construed to misconduct in office is unfounded. Only malfeasance committed during the existence of a duty under the office or under the color of the office and results from corrupt behavior constitutes misconduct in office. You know, and I think in this case, if you look at that, there was no corrupt behavior on the part of Sergeant.
That was one of the cases that you presented to the court. Okay.
This isn't corrupt behavior. Milton, he beat the inmate. He hit him repeatedly, knocked him down, slapped him, hit him. This was an individual where the court, the witnesses, the prosecutor, they may all disagree and say you should have done it differently. But there's different levels to this. This is a criminal court with specific elements. You know, there's administrative proceedings, civil proceedings, and other proceedings which you can address perceived wrongdoings. This is a criminal in which an individual's liberty is at stake. And they have to have probable cause to each element. I'm not asking the court to condone his conduct. You may disagree with what he did, but I'm asking you to find and hold them to the probable cause level of each element in this offense. Thank you, Your Honor.
All right, thank you. Mr. Dobie, anything?
Yes, briefly, Your Honor. First, I would ask that the court not place any reliance on the Graham case that was cited in the standards set there, because that is not applicable to criminal law in the state of Michigan. It is applicable in civil cases, but not in criminal cases.
I use that jury instruction repeatedly. It is adopted by the state of Michigan. It is the use of force. And I have standard jury instructions that your office provided me in which quotes that standard.
And as we go on, without belaboring the policies too much, I will just go on to the next paragraph of the policy that's cited. ASR can be used to subdue an unarmed attacker or to overcome resistance that is otherwise likely to result in injury or either the subject or the employee. ASR devices shall not be brandished as a form of intimidation. That is the policy on ASR. That is what he's trained. That is what he is supposed to be doing here. And that is absolutely not what happened in this case. It was malfeasance. The intent was corrupt. The Committee on Model Jury Instructions says to look at People versus Kotu for the definitions of that. Tainted or perverse use of the powers and privileges granted to him. Tainted means a trace of something bad or offensive. Perverted means misguided, distorted, misinterpreted, turned from what is considered right or true. We expect that officers will exercise their duties in a manner that is fair and equitable. Doing the opposite of that is what is meant by corrupt intent in a misconduct in office case.
Thank you. All right, Counsel, I want to make sure I take a look at everything that you presented to me, and I will give you another date to come back